Welcome, everybody, to the Labor and Employment Law section of the Orange County Bar Association, the monthly case updates. Today, we're going to discuss the cases published during the month of October of 2025. You receive, together with a link to this video, a copy of the case update summaries prepared by the law firm of Payne and Fears. And today, as our presenters, we have Andrea Paris, who is the principal of Paris Law PC. She dedicates her practice mostly of defending women or protecting women at work. We also have Alex Super, who is an associate at the law firm of Dorsey and Whitney LLP, where she concentrates her practice on defending employers in labor and employment law matters. I am Javier Rivera Carbone, your host. I'm a workplace attorney, investigator. And with this, I would like to now go to page 1 of the materials. And in page 1 of the materials, we're going to discuss one of the cases. And Alex, take over.
Great. Thank you so much, Javier. Yeah, so Calderon dealt with 3 plaintiffs who were 54, 55, and 56. They were dealer business managers at Circle K, generally positive performers. And essentially, they alleged that they were denied the opportunity to apply for and obtain the position of a West Coast regional director, which was ultimately provided to another employee who at the time was 45 years old and was the Southeast regional director. And so this case involved both claims under FEHA and the ADEA with respect to age discrimination. And so with respect to the McDonnell-Douglas burden shifting framework, the district court had decided and found that because the plaintiffs had not applied to the position, that they couldn't meet their prima facie case. And so the Ninth Circuit disagreed. And so on step 2 of the McDonnell-Douglas burden shifting framework, the Ninth Circuit had essentially distinguished facts of this case where there seemed to be no opportunity for the plaintiffs to apply, with cases in which there was an opportunity to apply and the plaintiffs chose not to. In this case specifically, the defendants, the employers, had essentially hand-selected the person that ended up getting the position. There was no opportunity to apply, despite, in addition, there being a policy that they would solicit applications generally. And so the Ninth Circuit essentially said, well, this case is different than those other failure to promote cases. And so because the plaintiffs had no opportunity to apply, they've met their prima facie case on step 2. With respect to step 4, in failure in age discrimination cases, the step 4 being that a substantially younger person was selected for the position, mostly focused on one of the plaintiffs who, Calderon, who was 54, who was the closest in age to the person who was selected. And so there was about a 9.3 year age gap between them. And so if we recall, there's a 10-year presumption. Being that if the 2 individuals are 10 years apart, there's a presumption of age discrimination, and if they're less than 10 years apart, there isn't a presumption. And essentially, the district court had said, well, he's younger than 10 years old, therefore, prima facie case fails on that fourth step. The Ninth Circuit again disagreed, saying that essentially the plaintiff can produce additional evidence to overcome the idea that the age difference was insubstantial or was not a part of the employer's decision making when deciding to select that new employee. And so essentially this plaintiff had produced evidence that the person who selected the new manager had said age related comments like you're too old for this business, or, you're out of touch. I want younger employees with MBAs. And so the court found that that was enough evidence to establish the prima facie case and move on to the legitimate, the step 2 and step 3. And so at that point, the court found that on step 2, the employer had produced enough evidence to show a legitimate non-discriminatory reason. At step 3, the court found that the plaintiffs had produced enough evidence of pretext, essentially pointing to those comments that I mentioned earlier, the fact that it was the person who selected, the new promotee for this position that said those comments. And the fact that the decision not to solicit applications was a deviation from their policy. And so that was the takeaway for me here, is that, employers should be consistent with posting with the policies that they post, meaning that if your policy is you always put out an application, don't deviate from that policy, because it could be used later on to establish pretext. And in addition, obviously documenting the reasons for the decision to hire someone based on merit. What I didn't mention was the person that was ultimately selected had a poor performance record, and so that, ultimately, like, weighed in the court's decision that there was pretext in that case. So, Andrea, from the plaintiff side, what's your take on this case? It's not great for employers. I think that's established.
Yes, that's correct. I was very excited about this case. I think that it is a great case for plaintiffs, not only in age discrimination cases, but anywhere that they have to establish a prima facie case in discrimination cases. A few things that were my takeaways was that plaintiffs were able to justify not applying for the position because defendants didn't post it like they did in the past. And like you said, the importance of being consistent in application of policy. But I think it's important for plaintiffs' counsel not to just look at policies, but the practices as well. And so doing discovery into the practice of job postings. So the fact that your client may not have applied for the job doesn't make the case dead on arrival. And, there are ways to get around that. So that was a great reminder for me to always look for inconsistent behavior on the employer's part. And the other point for me on the 10-year age difference was how helpful it was to look, or how helpful it would be for plaintiff's counsel to look at other circumstances that indicate that an employer considered plaintiff to be significantly older. Really look at, do the interviews, really talk to the client and get facts about any statements that were made related to the protected class that is the basis of the claim. So those were, definitely my two big takeaways for this case.
Now, in this case, the trial court said you don't even have a case. You don't even have a basic case. You don't even have a prima facie case. And the Ninth Circuit is saying, no, so fast, it's not that easy for the reasons that Alex explained. And Andrea says, well, this is great because now we can look at somebody, right? If they did not apply, that's a factor. And also the age gap, as discussed by both of you, from my perspective, I think it's fascinating here, because what if you have a succession plan? What if you are an employer and you know who you want for that position? And the Ninth Circuit, in this case, seems to be sending the message that if the employer is aware that somebody is interested in the position, they have to deal with that and manage that expectation, because it may turn, like in this case, in an age discrimination case. I also saw that it's fascinating that everybody here was over 40. So how old do you have to be? And the older I get, the more I ask that question. What's the difference between people? 9.5 years, 9.3. What about only 2 years? Would that make a difference? So this is an interesting case, I think, and we should all read it. And some are going to be happy, some not. But with that, we're going to move on page 3. And on page 3 of the materials, we have a case that is atypical because it comes from the National Labor Relations Board. Alex, if you can tell us what happened in that case, the NLRB case.
Yeah, so the North Mountain Foothills Apartments case, essentially, the holding of that case dealt with North Mountain. The employer made a number of constitutional challenges to an ALJ decision, that had resulted from the board, and so the ALJ had essentially found that this employer had engaged in a number of unfair labor practices after firing an employee for engaging in protective activity, essentially discussing their wages. And there was a number of the conduct that the employer had engaged, essentially interrogating the employee about whether or not they had discussed the compensation, issuing reprimands for doing it, threatening that, you can't do it again, and then ultimately discharging that employee. And so the employer, appealed that decision. And so they issued a number of constitutional challenges as well as to the merits of the ALJ's findings. And with respect to the constitutional challenges, the first was based on Article 2 removal protections. And so essentially the court rejected their argument and said that Article 2 does not require at-will removal. And secondly, that there was no attempt to remove the ALJ in this specific case. And so therefore there was no harm that, upon which that the employer could bring that argument. The second was a challenge based on the Seventh Amendment, the right to a jury trial, and the court essentially reaffirmed prior findings that the NLRB decisions are based in equity. They are equitable in nature, and therefore the right to a jury trial doesn't apply. The final and third constitutional challenge dealt with dual process, with respect to the dual investigative and adjudicatory functions of the NLRB. And essentially, the court found that there's not one person at the NLRB that's dealing with that. You have the NLRB GC who's dealing with the investigative and prosecution of the allegations, and then the ALJ who deals with the adjudication. And so the court rejected that challenge as well. And then just based on the merits of the claims, the court found that discussing compensation qualifies as a protected activity under the NLRB, meaning that the conduct that this employee engaged in was both concerted and for the mutual protection of other employees. And therefore, they essentially, sought to enforce the NLRB's findings, back pay, reinstatement. And so what I find interesting about this particular case is that, in California, we obviously have state law protections that protect with respect to discussing wages. And so something that's interesting about this is that it may be lawful under California law, but it may not be, and that the board may come in and decide otherwise. And so this is something for employers to keep in mind when they're deciding to discharge an employee who may have been engaging in adjacent conduct that might otherwise be lawful under California law. So it's just another consideration for employers to have as they're going through their decision-making process. How about you, Andrea?
On the plaintiff side, on the California side, I would still mostly rely on the Fair Pay Act and the pay transparency laws, but it is a good reminder that the NLRB still exists and still a threat to employers, and it is also a way to have additional leverage. If you were, negotiating pre-litigation, this may be something that, you throw into the demand letter, and it may put additional pressure on an employer as well.
And the Ninth Circuit Court of Appeal is telling us that the NLRB is okay, constitutional, and that the remedies, however big, they're discretionary and okay. So to the point of both of you, right, this is important for California employers because of the reasons of what you said. But to me, it's also important to mention that this was a non-union employer. So even if you don't have a union, the National Labor Relations Act protects employees at all workplaces. So be mindful, because some people shrug and say, oh, I don't have a union, this is not important. It may be for the reasons that Alex and Andrea explained. Thank you. But now we continue, moving on to page 5 of the materials. And on page 5, we have an interesting case to me because it keeps coming back every month of this year. We have an arbitration case. Andrea?
This is actually a fun one. Gergenis versus IGS Solutions. Here, the Court of Appeal, First District, Division 3, held that an employment agreement may be read in conjunction with other employment agreements that were simultaneously signed by the employee to determine whether read together the agreement to arbitrate is unconscionable. So the facts. Here, plaintiff was presented with 3 documents: an arbitration agreement, a voluntary dispute resolution policy, and a confidentiality and non-disclosure agreement, the CND, 5 months after she had already signed onboarding paperwork. So I'll go through the main provisions of each of the agreements. So the arbitration agreement itself covered disputes related to plaintiff's employment, but excluded certain claims, including claims seeking injunctive or declaratory relief regarding use or unauthorized disclosure of confidential information, types of cases that usually an employer would bring. Additionally, the arbitration agreement contains a confidentiality provisions stating that no party may disclose any information to any other party not involved in the arbitration hearing unless written approval has been given by the other party. Again, this would prevent the employee from conducting witness interviews outside of the discovery process in arbitration. It should be noted that the arbitration agreement stated that it was not a condition of employment, and it also contained an integration clause. The voluntary dispute resolution policy had a provision that was contrary to the arbitration agreement and provides that any dispute between the employee and IGS will be decided by binding arbitration if she signs the agreement. Also, it clearly states that the policy is not a condition of employment. Now, the third document, the CND, contains a dispute provision that permits IGS to enforce the CND in court and to obtain injunctive relief without posting a bond. Another provision that is something that, an action that the employer is more likely to bring than the employee. It is silent on whether the document is a condition of employment. Plaintiff Sarah Gergenis brought a disability discrimination and wrongful termination case under FEHA. IGS filed a motion to compel arbitration. Plaintiff opposed on unconscionability grounds and argued that the unconscionable provisions could not be cured by severance. The trial court denied the motion to compel arbitration and held that 1, a modest degree of procedural unconscionability inherent in employment, that there is a modest degree of procedural unconscionability inherent in employment relationships as the employees lack a meaningful opportunity to negotiate the terms. Secondly, that read together, the arbitration agreement and the CRD had the net effect of destroying the mutuality of arbitration. Further, the confidentiality provision restricted employees from contacting or interviewing potential witnesses outside of the formal discovery process, which also weighed in favor of finding substantive unconscionability. The Court of Appeal held that, one, it was proper to read the documents that were signed on the same day as part of the same transaction that also covered the same subject matter, that the arbitration agreement was found to have a high degree of substantive unconscionability based on the provisions when all three documents were viewed together. Secondly, the trial court was correct in finding that there was a lack of mutuality in the arbitration agreement and the CND, as claims that are typically brought by an employee are forced into arbitration, while the claims that are more likely to be brought by the employer may be brought in court. And the court also found that the trial court did not abuse its discretion by not severing the unconscionable terms, since there was more than one substantively unconscionable provision. So on the plaintiff's side, for me, the big takeaway is take a close look at all the documents that your client signed, because when viewed together, there may be conflicting terms. Employers don't always have all the documents drafted by the same attorney. They're not all drafted at the same time. And so they may miss those conflicting provisions. And it is a great opportunity for plaintiff's counsel to overcome that motion to compel arbitration. Alex, what do you think?
Yeah, I mean, definitely thinking about the cumulative effect of agreements signed not only like during onboarding, even though this particular employee signed them 5 months later, just like signed at the same time in the same seating, clicking through that online process that, sometimes employers have, which is efficient, but, in addition to that, ensuring that there's a separate arbitration agreement, as you were saying, obviously from the employer side, making sure that all of the terms are consistent. I also think the fact that here there was a policy in place that also contradicted the agreements that were signed. It gave the court just another reason to go on and interpret those agreements together, because it was just so clear that there was so much contradiction happening with respect to the employees' agreements and their policies. And so just ensuring, like, even if that employee is not signing a policy and it's a part of the handbook or, whatever it may be, ensuring that those terms in policies as well as in the agreements themselves are consistent.
I agree with both of you, but I also have to say that not all hope is lost. From the perspective of the employer, just the fact that there is a confidentiality agreement that allows the employer to go to court to get a quick remedy may not be what tipped the balance here, because in this case, the court found a high degree of things that were troublesome. And in the confidentiality agreement, it was not only the dispute over the confidential information, but there were also the disputes about intellectual property that went to court. So the result may have been different if the confidentiality agreement would have allowed for some things to go to court and some things to maybe go to mediation. I don't know, but my experience, corporate lawyers like to do confidentiality agreements, and employment lawyers sometimes are not consulted about confidentiality agreements. And in this case, the court is telling us when the two of them make a bad one, no arbitration for you, right? And from the perspective of the plaintiffs, sometimes they don't integrate all of the agreements. And to be fair, if you file a lawsuit and you get a letter inviting you to go to arbitration, and then you go to motion to compel arbitration, maybe the plaintiff doesn't even have all the documents. So would this allow for limited discovery? Does the employer have to do initial disclosures? What are we talking about here? Is it going to be harder now to get a motion to compel arbitration? I don't know. So like you said, Andrea, this is a fun one. So let me just then go to the last page of today's discussion. I think it's page 6.
May I make
the
one more
next one.
point, Javier?
I'm sorry?
May I make one more point?
Absolutely.
Okay, great.
The discussion is what makes this interesting. What the court said, the court already said, right?
Yeah, but what you make a good point about the confidentiality agreement. And the thing to note here that the court paid attention to in the confidentiality agreement was the fact that the employer was not required to post a bond. And I have seen and, negotiated those out quite a bit on behalf of clients. And so that is one thing to be mindful of too, that the courts do not look favorably on those provisions in the agreement, it seems.
So, Alex, what do you think of that?
Yeah, I mean, I definitely clocked the focus on the lack of posting a bond. As you know, I've seen plenty of agreements that we've drafted has that provision in it. And so yeah, I mean, I agree. I mean, I'm just going to be the opposite. Obviously, that's more favorable to the employer, and so you know, we would negotiate accordingly. So.
And the fact that this was presented after employment, does it bother any of you?
Yeah, that I would not advise doing that, definitely. If we obviously if there's changes that need to be made throughout the employment. I think, the other thing about this was there was no additional consideration provided 5 months later, and that posed an issue for the court as well, and that was discussed by the court. And so if you're moving through and you're providing documents after the employee has already started, particularly 5 months, 6 months, a year, taking into consideration the fact that maybe we need to think about what type of consideration should be provided under these similar circumstances.
So, Andrew, what do you think? Same difference? No difference? Big difference?
Yes, the fact that the court definitely made a point about the fact that there was no additional consideration provided, and I think that's also one of the facts that goes towards the imbalance of power. That although the language of the arbitration agreement says that signing this agreement is not a condition of employment, you're already employed, there's no additional consideration provided, an employee would feel compelled to sign an arbitration agreement that is provided to them under those circumstances.
I
Well,
would
thank
just
you
add,
for.
oh, sorry.
Oh, go ahead. I was going to say thank you for the practical perspective, but Alex, go ahead.
I was just going to add to the practical perspective a bit. I think, the court had noted that the HR person who presented these documents, had actually said, contrary to what was stated in the documents, that you have to sign these, something along those lines. And that was the understanding of the employee, and that she just signed them because she, felt like she couldn't, she didn't want to lose her employment if that was truly the case. And so from an HR perspective, being aware of how you present documents to the employees to sign is really important as well.
Agreed. So, thank you for your practical perspective, both of you. Finally, let's go to page 7 to another set of cases that seem to be coming every month, also in 2025. Les Paga. Andrea, what say you?
Okay, I will just briefly mention Galarza versus Dolgen, short for Dollar General, Cal LLC. In the published portion of this opinion, the Fifth District Court of Appeal held that the version of PAGA that was in effect from mid-2016 to mid-2024 authorizes an employee to bring a headless PAGA action on behalf of the LWDA to recover civil penalties for labor code violations suffered only by other employees without seeking penalties for violations that the plaintiff personally suffered as a way to avoid arbitration. The court reasoned that PAGA is a remedial statute that should be liberally construed to promote its purposes, and gave it more weight than the ordinary meaning of the statutory text. There was a whole discussion about the use of the word and. So the statute provides that an aggrieved employee may sue on behalf of himself or herself and other current or former employees. The court determined that this language was ambiguous on its face, and the legislative history was unclear as to whether the language allowed for a plaintiff to bring a suit on a representative basis alone. The court ultimately determined that a plaintiff should not be required to arbitrate because of the delay and potential for a less favorable outcome associated with arbitration. So this decision crystallizes a split within the Court of Appeal over the viability of headless PAGA claims, and the California Supreme Court has agreed to take up the issue on Leaper versus Shipped Inc. So we won't have clarity on the headless PAGA claim issue until the Supreme Court decides Leaper. However, what I take from this opinion is a reminder that if the text of the statute isn't clearly on your side, you can argue, especially on the plaintiff side, in employment cases, right? Argue the liberal construction of the statute, and that the liberal construction is necessary to serve the statute's purpose. So that's what I am taking from this case until we get clarity on the headless PAGA claims.
Alex, so clear, pages and pages for the definition of and. So what say you? What is your take home from this case?
I mean, I think the first thing that I noted when I was reviewing this case was that it's pre-amendments. So obviously there's been some new amendments to PAGA. And so, taking that into consideration, particularly with the new standing issue that came about for individual plaintiffs in the new amendments. I think I agree with Andrea that it's just something to keep in mind as we move forward. I think employers and employees, plaintiffs and defendants are eagerly waiting for the Supreme Court to weigh in at this point.
Not easy
Yeah.
to wait, but we have to wait because now it's less clear, I think. These are the cases that we have for today. But before we go, I want to invite everybody to join us. In December 2025, we're going to have an in-person holiday event at a really nice Italian restaurant. So go to ocbar.org, sign up, join all of us. It's going to be fun. I hope, I promise. And I also want to thank Andrea, Paris, Women at Work. Thank you for helping out today. Alex, super, Dorsey and Whitney. Thank you so much. And to the law firm of Payne and Fears for preparing the summaries every month. And with that, hope to see you soon. And thank you for joining us.
Thank you.